You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
Welcome, members of the jury, to today's episode. In today's episode, we're going to be talking about the distinction between rehabilitation and punishment. And what I mean by that is how in the criminal justice system, when someone commits a crime and they're ultimately convicted, whether it be via plea deal or by jury trial, well, then they have to suffer consequences. And imposing those consequences, one has to decide, are we strictly going to punish this individual, or are we going to attempt to rehabilitate this individual? I come from the belief that the criminal justice system and its primary goals were to rehabilitate every individual. And in my experience, I've seen how different types of systems implement that concept of punishment versus rehabilitation differently. And I think one of the biggest situations where that is on the forefront is when you look at the distinctions between how the juvenile criminal justice system works and how that is compared to the adult criminal justice system. The juvenile justice system, I think 100% puts rehabilitation first and focuses very lastly on how to actually punish these juveniles, these children, when they make these mistakes. Whereas an adult, I think, on the forefront is punishment. And what's sad is that sometimes these people who find themselves in the adult system, well, just days before would have been in the juvenile system. And so today I have a guest with me who is on the front line. He's in the trenches every single day, working with these juvenile justice and within the juvenile justice system. And so I'd like to welcome Javi to the show. Javi, welcome to Members of the Jury, and thank you for coming today.
Thank you, sir. It's a pleasure to be on. What is this, episode 2? I think I'm one of the original. I'm a founding member now. Does that count? If I'm second in line, I think so.
Well, we consider you one of the first 12 in the box, but jurors, you're always subject to challenge. So we'll just have to see whether or not any peremptories happen out there.
I'm expecting a plaque or something in the mail.
Well, we'll see. Some judges do give certificates. I don't know if we're there yet. But go ahead and let the members of the jury know a little bit about yourself, what you currently are doing.
Javier, I am a public defender. I've been a lawyer for about 3 years and a little change, all of them as a PD. I did a year and a half, or actually a year and like a month, doing misdemeanor jury trials with some really dope attorneys that fought alongside me. One of them was you. You and me did our first couple trials together. That was definitely fun. We've been in the trenches together, shouting out, you know what? No time waiver jury trials. After that, I transitioned into the juvenile delinquency division at the public defender's office, where I've been for a year and a couple months. Very big difference. That's about it for me as far as my legal career. But I'm Puerto Rican, born and raised, came out here for law school, said I was coming back to Puerto Rico after I graduated, but then I fell in with you crazy public defenders, and I've never even thought about leaving since I joined. So yeah, that's me.
What would you say that in your experience has been kind of one of the drastic differences between working in the adult criminal justice system compared to the juvenile criminal justice system?
Well, I mean, they're two totally different beasts. I mean, there's differences in outcomes, of course, because we're dealing with with children. So obviously punishment is not supposed to be a guiding principle when we're resolving cases. In practice, obviously we work in gray areas. We're attorneys. A big difference, and probably the biggest kind of smackdown with reality that I've had, is I was coming off of doing misdemeanor jury trials where, frankly, my biggest tool is that I am extra as hell. I am dramatic in front of a jury. I will sell you a story, even if the law is not lining up with my argument. You will bet that the basic human characteristics that I'm presenting to you are going to make you want to find for my client. In juvenile, we don't have juries. It's just judges. The judge decides what facts did or did not happen based on the evidence presented. So that means all of the emotional pleas, all of the people haven't met their burden, those arguments kind of go out the window. It's the difference between playing chess against a really smart person and a computer. They're both hard, but when you're playing against the computer, there's no emotional appeal, there's no stress that you can count on from the other side. You just have to have your strategy, you have to have your defense, you have to have your case law, and there's no wiggle room.
I know that shortly after you started working in the juvenile justice system, and we had a conversation, you were telling me how, like, kind of just like you were saying, like, the systems are so too different. And I think you were saying how, like, when you were in the dealing with adults, and a case comes before any, in a courtroom, it's kind of like the assumption is like, oh, this person fucked up. And now it's either up to the defense attorney to show maybe that they didn't, or to minimize that effect. But the prosecution and the judge are looking at this person as if they made a mistake and that they need to be punished. Whereas when you get cases across your desk in juvenile, as a collaborative court between yourselves, the prosecution, and the judge, their initial response is like, why did this happen, and almost immediately, how can we prevent it from happening again in the future? Would you say that's been your experience?
Absolutely. And again, right, it's varying degrees. So if you were to talk about just the absolute differences between adult and juvenile, yes. In juvenile court, I'm having a lot more conversations with prosecutors about, how do we set this kid up for success? You hear prosecutors when they're arguing for maybe terms of probation that we don't like, they're not, couching that in, we need to punish this minor. They're couching that in terms of, we need to make sure we have we can't let this kid out because we need an appropriate plan for when he gets out. Or, this custodial program, jail, basically, juvenile hall, is needed for this child for this reason that will benefit the child. As opposed to in adult court, where, it's been my experience, you get, people with non-violent drug possessions, and you have DA saying, well, he's gotten caught with heroin 4 other times, so I don't care that he's addicted to heroin. I care that he doesn't listen to what the judge says. Let's punish him and show him that he can't do whatever he wants. That's never a thing that I've heard in juvenile.
And you were saying that, like, and I think because of that obviously changes the way in which negotiations obviously take place within a case, right?
Well, absolutely. So, right. So the biggest fight for us, or at least in my practice, has been as defense attorneys, our biggest fight is, it isn't so much the charges, is what do the charges translate to for the future of this minor, right? So in adult court, you might see someone say, okay, well, if a case has 3 counts, right? You'll dismiss 1, but the DA and I will haggle over what the terms of probation should be, if there should be, 30 days of custody, no days of custody, if custody should be stayed. Those are all part of the negotiation before a client makes an admission, right? In juvenile, it doesn't really matter if the admission is to a misdemeanor or a felony. provided that, both are sealable under the different types of welfare and institutions code sealing requirements. But the DA and I have very little or no ability really to set a condition of probation as part of a negotiation. The admission, or we go to trial and we lose, whatever happens, all of that has to happen before we ever have any conversation about what this kid will or will not have to do.
And see, and here that's so crazy to me, because I know in my experience there's definitely been times where, like, me and the prosecution have come up with such almost like a detailed change of plea agreement, so to speak, that like the judge ultimately, and I've heard him say, I just feel like a rubber stamp. Like, you're taking all of my discretion and sentencing authority kind of away from me because you guys have already essentially come to these terms via the agreement. And like, that's not the way that I want to necessarily operate. And, but that's the way we've come to. And a lot of that kind of shows how, the prosecutors ultimately have a little bit more power than the judges, because most judges, when they see a change of plea come for them, they're going to accept it. And the terms of that sentence, on the most part, have been dictated by the prosecutor, not the judge. Where it seems like in your experience, like, no, the judge retains all of their judicial discretion and sentencing powers throughout the process.
Right. Well, I mean, yes, that is true. But you got to remember, we also have probation heavily involved, right? So the whole point of why a DA and I can't, create terms of probation before an admission is because right after the admission is made, probation steps in. They do what's called a social study. So, and basically that means they interview, the minor, the parents, the victims, if necessary. They go look at this kid's school records, his attendance records. Does he have extracurricular activities? Have there been psychological evaluations or evaluations that have been made? They look at all of that. They have all of these equations that they use that, frankly, I can't even understand half the time. And with that, they prepare, a 10, 11-page report with recommendations of what they think would be appropriate terms for supervision or for probation. Because at the end of the day, they are the ones that are supervising this probationary period. But even then, it's not decided. They give that report to the judge.
And that's regardless of whether it's a misdemeanor or felony, right?
Absolutely. So yes, the serious.
Well, I just realized that in juvenile, there's no such thing then as summary probation, like there is an adult, where the court serves as the probation, and they say, we're not going to have anyone checking up on you. We're not going to have anyone that you have to report to. We're just going to tell you, hey, you have to do these conditions, and if you do them, cool. If not, well, then we can throw you back in jail.
Well, it's not common, right? I mean, or not that it's not common, but it's not the majority of the cases that I see, but there is such a thing as summary probation in juvenile delinquency. It's called probation to the court. That's one alternative, right? So basically it's the judge saying, I'm going to cut probation out of this. Typically we'll see that when a kid has like maybe one or two requirements that are outstanding. So he had to do 40 hours of community service before he'll be successfully terminated off probation, and he's only done 35, right? The other thing that we do, which is interesting, there's a welfare and institutions code that allows a minor to be supervised by the court without being declared a ward. That also implies that probation does not have the same authority that they would under traditional formal probation, but that the judge has to make a special finding that this is a minor who would benefit from this informal type of supervision. And again, it always comes back to the same thing. Is this the type of minor that would benefit from this? Is this the type of minor that needs this? And it's less based on, is this the type of case that would require this, right? We don't talk about the case. We talk about the minor. And that small change it might sound kind of nuanced, but it completely dictates the approach to how a case moves through the system.
Yeah, that makes a lot of sense. And I mean, I know you were just telling me too recently, speaking about how a case moves through the system. I think that's a really great segue point that you were actually telling me that recently you and your organizations actually just became some of the first ever participants in a new way in which cases might operate through a system. Is that right?
Well, yeah, so that's true. And again, I am by no means an authority on this. I think we said it at the beginning. I've been a lawyer for 3 years, which sounds like I should know a lot. And I feel like if objectively I looked, I have learned a lot in those years. But when you're talking about people that have been practicing law for 30 years and kind of dictate the way that the criminal justice system makes these changes that now everybody wants to see, I really don't know anything. But putting that aside, yes. So I work in a county that was selected to basically run a pilot program. So the Center for Juvenile Justice, let me make sure I'm saying that right. Yes, so it's the Center for Juvenile Justice Reform. So this is a program out of Georgetown University, and their premise was very simple, right? So we all agree that there's a difference between adults and juveniles and that we need to prioritize helping these kids, A, not be offenders in the future because we know what happens in adult court, and B, what is lacking in these children's lives that either A, drives them to commit criminal offenses, or B, is not giving them the support that they need and the encouragement that they need to be productive, successful members of our society. So they basically started from zero. They're like, let's rebuild it from the ground up, theoretically, right? So they created all of these different models for how juvenile delinquency courts should be run. And then after they did that, they selected a number of states and counties to basically implement this process or implement this practice model. Now, where I work, we're actually the first county, rather, the probation department in my county was selected to basically have a contract with Georgetown University. And they're working with probation to implement this new process. And what probation turned around and did, which was very cool, is they brought in what they call all the stakeholders in the juvenile delinquency courts. So that means the bench, the judges, the prosecutors, the district attorney's office, and the public defender's office, as well as some members of the private bar. The logic behind this is, look, we're all going to work this system together. It either works or it fails with us. So it hasn't been implemented yet because, like everything else in a bureaucracy, there's a lot of back and forth. There's a lot of, is this the best way to serve it? And obviously, intelligent people will disagree. That's the beauty of having smart people running all of these departments, is they don't always think the best thing is the same thing. But yeah, as far as what the new model that we're trying to incorporate, the name for it is the Youth in Custody Practice Model. And it basically focuses on if a kid, a minor, is arrested for an offense and they're in juvenile hall, what do we need to do from minute number one all the way up until the day that minor returns into society to make sure that this never happens again? And it, obviously it's very complicated and it requires a lot of steps, but it's a very different way of rethinking how we do criminal justice and specifically juvenile justice.
Well, I hope that really works out. That sounds like an amazing program, and hopefully with the right foundational steps, it might be able to be implemented at an adult level as well. I know one of the big distinctions too, and prior to today, we've had the conversations that I think that exists in the juvenile realm that doesn't exist in the adult realm, which there's movements to kind of push for, is that the aspect of bail. In the adult court, you get charged with certain offenses that have a specific nominal figure attached, that if you get booked into custody, you have bail set, and you have an opportunity to get released on your own recognizance or even potentially supervised. But at the end of the day, if that gets denied and you're sentenced, to pretrial detainment, and you're, don't have that high level of incomes, you're ultimately sitting in custody until who knows when. And I know that the juvenile system, they don't have bail. right? They work on more of a kind of merit-based system, which ultimately, if the bail system was to be abolished, the adult court would take up something similar. So what's been your experience in kind of in operating now in kind of a no bail system?
Yeah, it's not my favorite thing. Mostly because, like, a judge is deciding. So again, in adult court, obviously, a judge is determining a bail amount, except unless it's, very serious murder charges or something to that effect, where a judge is imposing a no bail hold. Um, Absent that, right, the judge is really just deciding how much money does this person have to pay? Like, how much is enough to, really make them understand that they need to A, stay out of trouble, and B, come back to court. That system, just kind of by its very definition, does not work in juvenile because kids don't have money. They don't have jobs. The kids that do have money, they have money because of their parents. So you could set that bail at, $5 or $5,000. That kid didn't work a job to pay for it. Their parents did. And most of the kids that we see that are coming before the court in juvenile delinquency or juvenile justice, which is rather the name I should be using, they either A, don't really have that parental support, or they don't listen to their parents. So money really does not play a significant role in whether these kids are going to follow the rules or not. So that necessitates the judge to kind of make a value-based decision. Is this a kid that A, is going to listen to what I say? Is he going to be safe? Is the community going to be safe? And is he going to come back to court? The biggest problem that I have is that we're dealing in absolutes with very little information. When I get a kid who's just been arrested and charged, I don't have a police report. I don't have a psychological evaluation of this kid. I got a 2-page report from probation saying, he did this. We don't know what to do, so let's be safe rather than sorry and keep him detained.
Well, are the laws for pretrial detainment in juvenile the same or similar to the ones in adult, where basically you have to
Factors.
if you have someone detained, you got to get them before judge within, by law it's like 48 hours, but in practice it normally amounts to like 72 because of depending when you were booked in, or they don't account weekends and stuff like that. So you're saying they still have to abide by that, but most of the times you're not even given the police report in that situation.
Correct. We don't get the police reports ahead of time. And the reason for that is a lot of the time we haven't been appointed prior to that initial detention hearing. And juvenile justice is 100% confidential, right? So we can't get our hands on those police reports until either A, the public defender's office is presumed to be the working attorney. But in practice, within a day or two, we're not going to have the DA's office sending police reports to cases that we're never going to work.
If at the detention hearing release is denied, and then you subsequently get the police report that allows you to, shed more light on the situation, does that allow for then a renewal at least to the judge to ask for release?
You can argue for a changed circumstance like you do in adult court, of course. But, you're coming off against the very realistic, although often acknowledged or often not acknowledged, issue that judges are very hard pressed to overturn each other. If a judge denied a release 3 days ago and then you got your hands on the police report and you're like, my kid is barely ID'd here, or this ID is BS. Look at all these valid arguments that I have. You're going to have a very difficult time because you're arguing the facts to a judge, and they're going to tell you, for purposes, the song and dance, for purposes of bail, I have to assume that he did this regardless of evidentiary issues. And now on top of that, I have to basically say on the record, the judge, my colleague who just saw this case 3 days ago, is wrong, and I'm going to go ahead and reverse his decision. They're not inclined to do that. I mean, I don't love it, man, especially because there's so little information at that original detention report, right? The DA obviously has the police reports.
Right. From the get-go.
Right, which is a thing that to me it's funny, but it's more infuriating than funny, is and I know you've probably been through this too, you get an original police report, in your case adult, or I get a detention report in juvenile, and I go, there's on its face issue here, and I'm going to use that to my advantage for my client to go home. And you get up there in front of the judge and you argue it, and then you hear the DA go, well, this other piece of evidence that we haven't disclosed yet completely refutes that, and it's terrible for this case. And here you go, judge, take it as true. We'll make sure to give it over to the defense team at our convenience. Like, that part is
Right.
It's frustrating, but you're basically stuck arguing against something you don't know. And we always make the same argument, and it never works. Well, if the people are privy to information that I'm not, I certainly would appreciate it. And the judge is going to say, well, I understand how you feel, but I'm going to take them at their word, and your client's staying in.
Yeah. As we wrap up, Javi, let me ask you this. When we started, we talked about how, definitely the distinctions between juvenile court and adult court kind of embody the distinction between focusing on rehabilitation versus punishment. And obviously what the goal of that is to minimize recidivism and, continual, as I like to say, having a revolving door in the system. Do you feel that ultimately by focusing on rehabilitation first, the juvenile justice system does a good job of minimizing recidivism and keeping those juveniles from coming back and being repeat offenders?
I believe that fully. I mean, the thing about juvenile justice, so let me just say this. When I started working juvenile, we were calling it the juvenile delinquency department of the public defender's office, right? We are, or not we, but the people above me and just kind of the entire team and community that deal with juveniles, they're saying, we don't even want to call this delinquency. This is juvenile justice, because we're not just looking for justice to victims. We're looking for justice for minors who, don't benefit from parental support or community support or support in their schools. It's about equity, right? It's about making sure that kids have the tools to be successful in the future. And that necessarily means that when a kid commits a crime, we need to look past that, right? We can't just look at the charges and say, well, this kid's fucking up, we need to punish him. We need to start asking really hard questions. I mean, they're not hard for me, I'm a defense attorney, but really hard questions from the bench and the DA of why did this happen? What led this kid to this decision? And when we start having conversations like that, maybe you have a serious felony where really the only thing the kid needs is a mentor. Maybe you have a kid who only committed a misdemeanor petty theft, but the level of undiagnosed psychological conditions and the maybe abuse that he's suffering at home necessitate that, we got to put this kid in a different environment where he can flourish. And those are the types of conversations that I really enjoy about juvenile justice. And I think that those are exactly the types of conversations that reduce recidivism. Not how do we punish someone for fucking up, but how do we give someone the tools for them to decide that they're not going to fuck up anymore.
I think that's a really key point, because not everybody, obviously we love to live under the principle of all men are created equal, but we know not all men have the same tools available to them. And so I think that by doing that, even if it is through that process of being in the criminal justice system, so be it. I think that should always be the first focus. Well, we want to thank you so much for coming onto the show, Javi, taking the time to take it to the box. We hope you come back, and we'd love to hear from you again.
Of course, buddy. Thanks for having me.
Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. The information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.